Welcome to Wills and Living Trusts. How to avoid the three biggest mistakes that people make. My name is Jason English. I'm an estate planning attorney here in Austin with Jason English Law. And I've been practicing law for years, and one of the most heartbreaking things that we see are families that are going through unnecessary legal struggles after losing a loved one. These struggles, they could be prevented with proper estate planning. And during this webinar, we're going to teach you how to avoid the bad situations that occur in estate planning and that we see all too often. Imagine this. You've worked hard your whole life. You've built something valuable, talking about your home, your savings, maybe even a business. And you've always assumed that when the time came that your family would be taken care of. But what if I told you one overlooked legal detail could turn everything you've built into a legal nightmare? I'm talking about courts that are controlling your assets, expensive legal battles, and family members fighting over what's rightfully theirs, all because of simple, preventable mistakes. And this happens every single day to hardworking people just like you. But today, we're going to talk about a simple way to protect everything you own and make sure that your loved ones are taken care of without the stress, delays, or even unnecessary legal fees. So stick with me for the next few minutes, and I'll reveal exactly how to safeguard your legacy.
During this webinar, we promise to teach you how to make sure 100% of your assets go to the people that you love, how to avoid Texas probate, the difference between a will and living trusts, why putting assets in your children's name might not be the right thing to do. It may be a mistake. How to safeguard an inheritance from divorce, from lawsuits, creditors, irresponsible spending, and more. How to provide for a beneficiary who receives government benefits. Let me tell you a little bit more about me. I'm an estate planning lawyer in Austin who started my firm in 2017, where we help people sleep better at night and get peace of mind by creating a plan to provide for and protect your family's future after you're gone. I grew up in a family of lots of lawyers and in my dad's law firm. And during law school, I was writing wills and doing other estate planning documents. And then when I became a lawyer, my dad had me doing estate planning and probating wills. And during that time, my dad always told me, he said, go to the DA's office for a couple of years, work as a prosecutor and get some trial experience. Well, I took my dad's advice and I spent about 15 years as a prosecutor. Then in 2017, I left the district attorney's office and started my own firm to help people, because dying without an estate plan just makes a bad situation worse for your family. Remember to ask your questions. You're going to be seeing a box below the video that says Q&A. And if you want to type something in that box, it'll come to me and I'll get to as many of those as possible at the end of the presentation. And if I don't get to yours specifically, I'll do my best to answer you directly over email as soon as I can. So part one, probate, why to avoid it. The biggest problem is mistake number one, is not having any sort of documentation, not a will or trust after you've passed. This means that your family is going to have to go 100% to probate court, and they're going to have to deal with the bad situation I've alluded to. I'm going to discuss more in detail. With that story in mind, let me start off with Beth. The story is about a widow that I'm going to call Beth, who was referred to me by another client. Her husband Earl had just passed and Beth had filed the probate. She filed it incorrectly and just didn't know. There was no will in place when Earl passed, and Earl left a local accounting business behind without any succession planning in place. On top of that, he left behind two estranged daughters from her previous marriage, and Beth filed the probate without including those two daughters. The big issue that she ran into is that in Texas, if you pass without a will or trust, the state of Texas decides how to divide up your property according to what's called intestate succession. And if your children are also the children of your surviving spouse, then it's all goes to your surviving spouse. But if your children are from a different parent or relationship other than your spouse, the estate's going to be split between the surviving spouse and the children. And so to add insult to injury, Earl didn't add Beth to the deed of the house. And so what that means is that the home that she lived in for 23 years, it now had to be split between herself and Earl's two estranged daughters, whom she'd only met twice. It caused her a lot of pain and suffering and stuff, something that Earl would have never wanted her to deal with. In this case, it's going on for, I think, around 2 years, and it doesn't look like it's ending anytime soon. And so I want to talk to you about when you don't want to be in my office. And so, like many of attorneys that focus on estate planning, there's two ways to help people. One is in the capacity that I explained with Beth as a litigator fighting against another attorney to prove whether you or someone else has rights to something that your family owned. The other way that I can help is by providing them a plan and planning ahead. And when someone plans ahead, they're just much easier options to go through, which we're going to get to later in this presentation. But first, let's start with the situation that we're trying to avoid. Let's talk about Texas probate. Probate's a process of dividing someone's assets after they pass away. And there are different rules for probate in different states, but obviously, since we're in Texas, we're going to focus on Texas law here. And in Texas, you can draft a will or a trust that allows you to instruct your heirs how to divide your assets. And if there's not a will or trust, then the law clearly explains how your assets will be divided according to the state law. The laws in place are meant to be fair. And as you can imagine, there's a lot at stake financially, and people will sometimes they'll try to do some sneaky things to get more than their fair share of a person's estate. We're talking about documents disappearing, made up documents suddenly appearing, forcing people to sign things under threat, all kinds of stuff that you'd never dream of. And in order to avoid that, you either need to provide specific instructions in Texas regarding how you want your stuff to be handled, or it's going to go through a process to handle it for you. The state has a plan for you. Regardless of whether your issues, if you don't have a plan, or if you have a plan that doesn't hold up in court, you're going to find yourself in the default situation, which is probate court. That means your bank accounts, your home, anything that you have. The estate's going to go to what's called a personal representative, who will be chosen by the court if it's not specified in a will, and that person will be responsible for selling any of the assets that will be divided. Think back to our story about Beth. That's what happened here. Texas costs. So time is a big cost, but don't forget about the real tangible cost. It means attorney's fees, paying for an accountant, appraiser, potentially other professionals such as real estate agents and brokers. The value of any asset is determined by fair market value, so that there's no ways to fudge those numbers. Around here, that basically means anyone who owns land or a house, they've been putting money into their retirement account, has a life insurance policy, a few nice cars, they're going to need a team of professionals to handle probating those assets. There are estimates that probates can easily eat up 3% of a state's value for an uncontested probate, while contested probates get much more expensive with additional attorney's fees. Simple uncontested probates in Texas can cost from $4,000 and up, and those more complex cases can easily start at $10,000, $12,000 and go up. Keep in mind, that's all money that isn't going to go to your family. Talking about timelines, the overall process of probate takes several months in Texas. We have to secure court dates for hearings, appoint a personal representative for the will, wait for creditors to make claims for debts against the estate, and anything that ends up being disputed. Sounds easy, right? Well, it can be if there's a simple situation, but those are sometimes pretty rare. When someone ends up passing without a will or a record of their assets, the only person who has the full picture of what assets that make up their estate is not there to guide the process. So new assets can come into the picture. Situations with deeds and bank accounts that your family might never have known about will surface. And any one of these can change what interested beneficiaries want or don't want. Typically, this will end up taking a minimum of 6 months in Texas for a simple probate where everyone agrees, while average probates can take 12 months or more. That can be 12 months or more of fighting, potentially without access to the assets of the person who passed away. Keep in mind, mortgages and bills will need to be paid during that time too. I want to talk to you about privacy and creditors. And beyond all those fees that we're talking about, one of the nasty things about probate is that Texas law requires everything to be put in the public record. If you have a mortgage, you better believe the bank's wanting to have a chat with you to make sure who's going to keep paying it. Or if you've taken out any loans for anything else, the same thing they're going to want to know. How well do you really know your family, your children, your siblings? The last and most important drawback to going through the probate is the toll it takes on your family. Often the probate process will bring out the worst in your family. Have you ever heard that joke about families that get mad at each other after playing some heated game of Monopoly? Well, dial that up to 11, because probate, man, it's dealing with real money in actual houses. All the events that I've mentioned in this section are stressful, in and of themselves, not to mention the fact that people have to grieve for the loss of a loved one. It's an absolute powder keg of emotions that really brings out the worst in some people. You may think you know your siblings or your kids, but I can tell you certainly there's no way to predict how things will shake out when money's on the table. When you don't have a plan for how you want your wishes to be carried out, you end up creating a situation where your family will battle it out in court. That means that they're really not going to spend Christmas and the holidays together anymore. And it's not something you want to happen. We talked to you about the biggest mistakes, part two. It sounds like probate court isn't the right way to go. And I agree. But unfortunately, getting a plan in place isn't always as easy as just signing a piece of paper. This is actually biggest mistake number two, thinking that you're set, ready to go with some peace of mind, while in reality, you get an invalid will or an unfunded trust, and it's sending your loved ones to litigation. And unfortunately, this mistake that some attorneys themselves can cause, not to mention all those legal document providers out there that advertise the do-it-yourself method. Let me tell you, our goal at Jason English Law is to help clients avoid spending money on estate planning, only to end up with similar outcome as mistake number one, and end up in litigation and waiting through court processes to have to get anything done. Even if you don't want to continue working with me, I urge you, find an estate planning attorney and ask that attorney how your planning works. If there's anything you need to do after you sign the documents, then make sure that your family is protected. I've got another story regarding this. It kind of hits pretty close to home. Let me give you that rundown. We're going to call this Ben's story. This story is about why you can't leave these things up to chance. Unfortunately, you never know when your time's up. And that's the problem with my client's father faced. Ben's father, Mike, he was a smart and successful businessman. He had a seven-figure service-based business that he built himself, and he was sure it was going to provide for him and his family for years to come. He had various properties he wanted to make sure went to his kids when he passed. And he'd used lawyers both in a personal capacity as well as a professional capacity all his life. But for some reason, Mike did some DIY estate planning. He made himself a will in addition to a trust that he had. Well, Mike unexpectedly died of a heart attack. His will was no good, and he never got around to actually putting those properties into the trust. That means that the estate ended up going to probate, and then it was split between Ben and his sisters and Mike's second wife. And when Mike passed, the wife raised her salary at the business to over $250,000, tried to sell off the properties. It turned into a huge, very expensive fight in probate court with 4 to 5 lawyers. It's lasted over 2 years now. It unfortunately destroyed the relationship with Mike's wife. And the really unfortunate part of the story is that Mike, he thought he had everything set up correctly, but time wasn't on his side. If he would have added the properties to the trust, there's a good chance that the family wouldn't be at each other's throats right now. And so I want to talk to you about those DIY solutions. You might be familiar with the ones online services or other things that allow you to get legal documents that generated automatically for a small fee. These companies some of them are relatively new, but the concept has been around for decades. Before LegalZoom, you were actually able to get a blank physical will at Staples. And even some states provide those as a public service to help people. Sounds like a great plan, right? Well, and sometimes it is, but if you happen to have an incredibly simple situation, maybe you're covered. But if you have no assets, no plans to deviate from the state's plan, if it fails, those will be okay for you. But I tell you, the minute the situation changes, you have children, you get a house, you're going to be in a situation where the risk it's just too great that plan's going to fail. By definition, these have to be a one size fit all. Otherwise, how could they make these documents fit everybody across the country? Not to mention the laws are different and continue to evolve in all 50 states. But these documents, they're often meant to fit everybody. They were made on who knows what date. Some of these documents are close to working, but close is just not going to cut it here. And small issues that you think maybe as irrelevant, they can cause huge issues. You're going to see these documents that are getting invalidated all of the time in court proceedings because they weren't updated or procedures weren't followed to make them legitimate. And the worst aspect of it, in my opinion, is that it gives you this false sense of security. You think you're fine, but when the day finally comes, you actually doomed your family to probate. Let me talk to you about some concerns over witnesses. Remember when we mentioned that the law was in place to protect people from bad actors? Well, One of the ways it does that is by having measures in place to prove that a document's legitimate. Otherwise, a bad apple error could come out of the blue with a document saying that the person who passed away left all the assets to them, and there would be no way to contest it. I remember a meme that said, "Hey, dad died without a will, but the maid found one and it all goes to her." I admit it's funny, but in all actuality, it's pretty scary. And for a will to be admitted, it has to be proven in order to be legitimate, with the signature of witnesses and notarization. And if an issue pops up that we frequently see is one that happens with DIY or inexperienced lawyer situations, is when the witnesses were not done correctly or not selecting the proper witnesses. For example, if you have a beneficiary be a witness, it raises the issue of undue influence, which will lead you back into the state deciding how an estate is divided up. If you go through this process correctly and it can't be proven that the witnesses were present for the document, it's going to get thrown out the same way that the document for a bad apple heir who wanted everything would get thrown out. And guess where that leads you? You're going to be back in probate court with the state of Texas deciding how to split property. Not funding the trust. That's a problem. And we're going to get to what a trust is in a bit. But in short, if you put your assets into a trust, you can avoid the probate process by giving those assets to your family through a trust. The problem sometimes is that people get the trust documents created correctly, but they don't actually put their assets into the trust. And this process is referred to as funding the trust. Any asset must be named and placed into the trust to be passed on, avoiding probate. It's estimated that probably about as much as 50% of current trusts out there, they're never funded, which is pretty shocking. And if this part isn't done, all of your beneficiaries, the only thing they're going to get is a piece of paper. That's obviously not the outcome that people planned when the trust was created. Which brings me to the next point, not keeping the plan current. Life comes at you fast and situations change for both you and the law. Estate law in Texas evolves, which is part of my job as an attorney, is to keep up on the rules that were in place when a will was drafted, as those may change and the law changes. And on average, we're seeing that probably changes, well, the legislature's in every 2 years, and so it could change every 2 years. In your situation, it's also going to change. You may have a new house, a new child, a divorce. It's stuff that you need to stay on top of. And if the plan's not updated, you may end up having someone who was the best option at one point in time and control of your entire estate, which may not be the best option later. A really common thing that you'll see with younger people is naming their mom as a beneficiary for the will. Well, what happens 50 years have passed and mom's on government benefits or has passed away? This kind of thing, a focused estate law practice will be able to help with that someone with less focus usually won't have the time to know or to deal with. That's going to bring us to part number 3. We're talking about a plan for success. Let's change gears and show you how things can actually be done right. Biggest mistake number 3 is not so much a mistake, but it's an example of how things can go right. We're going to call it the anti-story, Jared and Janice. I know we've coupled a couple of unfortunate stories so far, but luckily there are success stories too. And I've got a ton of positive stories that I could tell you, but they're just not as exciting. And that's really what we're aiming for. So this is a story about Jared, who came in to see me. Jared's cancer had returned, and he really didn't have very long to live. He'd been lucky and won the first battle, but he didn't make it through a second. But by this time, we'd put a trust in place for his entire estate to go to his wife, Janice, and his 2 kids. Janice didn't call us to let us know that Jared had passed away until weeks later because she didn't need to. Everything went smoothly with the trust, powers of attorney, funeral plot. When Janice did call, she didn't need any help with anything as they were almost done with everything. No family drama, and Jared was given the proper ceremony that he deserved. It's not a very exciting story, is it? But that's what we want, and that's what you want too. I've seen families fall apart due to an unexpected death, and it's not pretty. We want your legacy to live on and for your friends and family to be taken care of without the added stress of probate. My philosophy dealing with peace of mind for our clients, because everybody's got different needs. My philosophy on estate planning is that I want everyone who walks into my office to leave with peace of mind. We've gone over a lot of ways this kind of thing can go wrong, but with the right plan in place, you'll be able to go through your life knowing that your wishes will be carried out no matter what happens. Another thing I firmly believe in is that Peace of mind comes from the right plan for you. There's no perfect one size fits all estate plan. It's about what's right for you and creating a plan that works for your family's values. Everyone needs to have legal documents in place, but depending on the amount of assets you have, you might need to consider tax implications for your heirs. You might even want to have the option to do more with your money than what you thought was possible. So let's get back to some of the legal stuff. And what is a will? The first big document is a will. When done properly with the appropriate witnesses and all of the other stuff we've gone over, a will instructs the court on how to divide your assets. Even the most advanced estate plans include a will. One of the things to keep in mind, though, is that a will still requires your heirs to open a probate with all the costs and exposure associated with that. The big hassle that you are going to be able to avoid with a will is how your assets are to be divided. So, assuming everything is done properly and it's up to date, you can save your family the conflict in deciding who gets what, longer timelines associated with hearings, and in most cases, avoiding litigation between family members down the road. So, what's a trust? A trust is a much more sophisticated document. It's going to give your family flexibility to divide your estate without going through probate. You can put your house, your bank accounts, and everything else into a trust. And when you put things into your own trust itself, you're able to avoid probate entirely. Trust also allow you to choose how and when people receive their assets, which can be a very important thing in some situations, such as if you have young children or heirs who might need more financial guidance. Let's talk about the inheritance that nobody wants, the tax burden. And so when most attorneys talk about estate taxes, they're talking about an inheritance tax. But the federal limit is just north of $12 million these days, which most American families don't have to worry about. But that threshold is supposed to be dropping by about half in 2026 if Congress does nothing. But you never know, it could drop even lower faster if they decide to do something. So for anyone near that threshold of $6 million, or even less, depending on how much of a risk you want to take with the actions of Congress, you should be thinking about federal estate taxes. It also doesn't mean that you don't have to worry about your heirs paying other taxes if you don't have to worry about estate taxes per se. Let me use the example of an IRA beneficiary trust that we can set up for clients to have an IRA. As you may know, you pay taxes on the front end for an IRA, so you don't have to pay them out on the back end as long as you're older than 60. The key word in that scheme is you. You know, there are rules that where your spouse can inherit it with the same rules, but once it gets to a child or anyone else in the mix, it becomes a taxable event. That person has 10 years to withdraw the entire amount of the IRA, which is a taxable at the current tax bracket, which could be as high as 37% of the total value. And very few attorneys, let alone everyday people signing up for an IRA, are aware of this kind of thing. This is one of those strategies that we use to make sure that your heirs get as much as they can. I've also seen clients that try to give their assets to their kids before they pass or name their kids on an account, which can also have tax consequences. Do I need a will or a trust? Let me give you a classic lawyer answer and say it depends. And here are the major reasons, or I want to talk to you about the major reasons why I'm going to recommend a trust over a will when someone walks into my office. First, if they have assets over $150,000. If it doesn't seem clear by now, I'm not a fan of the probate process and what it does to families. There are absolutely situations where it could cost more to get a trust than what it would stand to lose through court proceedings and legal fees. Based on a lot of numbers from the AARP that we went over earlier, the number is a lot lower than what most people think. It's not just the Rockefellers of the world that need a trust. If you have assets worth over $150,000 on average, it'll be much less expensive to have a trust. Now, keep in mind, this isn't the amount of money you have in your checking account today. This includes your home equity, your financial accounts, your 401k, an IRA, if you have one, and then one thing that a lot of people tend to forget, life insurance policy, if you have one. So having any of these individually, they can put you over the $150,000 net worth. And if that's the case, I'm going to always recommend a trust. You know, if you own a home or real estate, I'm always going to recommend a trust because a home is the big asset and oftentimes it's tied to a lot of memories. It's one of the things you're going to see fought over the most in court. And as we've gone over before, you may think you know your family, but it's very easy to get in a heated fight over a home in probate court, which means money's going to be spent in the course. Even if your heirs get along perfectly, you now have a situation where they are joint landlords. What I'm talking about is they equally split what's the default state law. Everyone's going to have a portion of that home. They're going to share it equally. So if there's 4 people, they're going to all have a quarter of it. So if they decide to sell it, oftentimes there's going to be a conflict. One person will end up doing most of the work. One of the siblings will want to hold out for a better offer, and somebody may refuse to sell it at all. And so putting it in a trust, you can set out specific rules for how you want your home to be handled. Who's going to handle it? Who's going to do what? How you want it sold? How you want the proceeds to be divided up? And the list goes on. It's going to be a much more flexible way to set up the rules on your terms. One of the biggest things for, where trust is clearly better than a will is going to be for people with minor children. One group of people I always recommend using a trust is people with minor children. There are a lot of reasons surrounding guardianship, which could be the subject of its own webinar. But something that will always raise eyebrows when I bring it up is your kids will be getting everything the day they turn 18. Now, I don't want to make any assumptions about you or your life, but most people, they're not at their peak physical responsibility the same year they graduate high school. The likelihood of your assets making life easier for your children goes dramatically down if they get it at a young age. And the chance of it actually hurting them through poor spending or dangerous habits, it actually goes up quite a bit. I haven't seen an official study, but there's comparable situations that we want to point to, maybe consider lottery winners. I think there's something like over 70% of them end up going broke within a few years, and over a third of them go bankrupt after being used to spending lots of money. And all this can be avoided by setting up rules for distribution in your trust. So don't let this happen to your kids. One thing that's obvious is going to be supplemental needs dependents. Supplemental needs dependents can be, they can be in trouble if they end up receiving assets in a lump sum. There are big costs associated with caring for people with supplemental needs that will last their entire lives. In addition, we have state and federal programs to help pay for these. But when somebody with supplemental needs gets a big distribution for their bank account, it can kick them off their benefits. They'll end up footing the bill for their own care until the money goes out, and then they'll be back to square one with applying for benefits. A much better situation is get into the supplemental needs trust that can be structured to make sure that they have money for the care and other things in their life as long as possible. Let's next talk about problem children or challenge dependents. This one's not going to be super fun to talk about, but it's a big reason to have a trust. We're talking about people who would be at a bad spot if they ended up getting a bunch of money. If you've got a child or a dependent that has serious issues or maybe had one in the past, money can be very dangerous. We're talking about stuff like drinking problems, drug problems, gambling, bad business decisions, and that sort of thing. These scenarios, the best outcome is, the inheritance may get wiped out in a short order, but the worst case scenario can be life threatening. When a probate or will is settled, the money is going to be given in one lump sum. But with the trust, you can set up rules as to when and how much money is given out. A simple way to address this is by splitting the inheritance into annual or monthly payments. But you can get as complex as requiring stuff like drug tests if necessary to receive the installments. This can turn a potential nightmare situation into a way for people to do better for themselves, which is really what this is all about. This is what we want. The next one that I want to talk to you about is going to be second marriage or blended families. We talked about this a little bit about the default rules in Texas for dividing an estate, how Texas law decides how to divide it differently if children are involved. Well, the outcomes based on those rules can become even harder to deal with when you consider a blended family, as we learned about in the first story. The truth is, a lot of these rules were written when people didn't live to the age that we see today. Divorce was rare, and remarrying was even more rare. So if you have a blended family or children from a previous marriage, things can get very complicated quickly. When we're talking about second marriages with children involved, almost no two situations are alike. And the default situation with probate almost never reflects the real life situation. So if you have a second marriage or a blended family, I'm going to highly recommend looking into a trust. That leads me to what's your story going to be, which is a great segue into what I want to leave you with. We've talked about legal documents throughout this presentation, and I've also told you some stories. I want you to think about what your story is going to be, what you want to set up, or what's your plan or lack of plan.
Now let me answer some of the Q&A questions that have been coming in. Let's see. I have a will from 11 years ago. Will you take a look? Absolutely. We're happy to look at it, look at what's changed in your life and the law, look at what your goals are, and see if that will still works. Who should get copies of an estate plan? You know, your executor, your trustee, your family. You know, maybe we should ask, is there anybody that shouldn't? If we plan on having more kids, should we wait? Absolutely not. Don't wait. You know, there's always ways that we can make future changes for kiddos in the future. Let's see, one of my parents went to a nursing home. Is it too late to protect those assets? You know, it may be. We just have to look at that situation. I don't really have that large of a estate. Do I really need a trust? Yes. If you own anything in your name and you want to make it easier for your family, you know, save money, avoid probate, you've got to put it in a trust. What's a living will? Do I need one? You know, this is where we're talking about making end-of-life decisions. If you're plugged into a machine, you're expected to die. If you're not kept on the machine, you don't want your family to have to make that decision. You imagine the guilt that they would feel. What's the price? We'll get to that in a second. So looking at the time, we have some additional questions, and we will reach out to those of you that asked those either by phone or by email. But I want to talk. If this information resonated with you, I'd love to help you take the next step. As promised, we've got a special offer for you. And if you've received all you need from this webinar, you're free to go. But for those that who are interested, let me tell you what we have in store for you. You know, the truth is, everyone has a unique situation, their assets, their family, and their goals. And it's going to take expert help to make sure that you have the right legal plan in place for you and for your family. You know, simply, there's no substitute for sitting down with a professional to complete your estate planning. Once you get it set up, you're going to have that peace of mind knowing that you and your family will be taken care of in almost any situation. And if you walked in our office off the street, we're going to charge you $500 to meet with us for an estate planning consultation. That's so we can get your situation assessed, figure out, explain stuff to you. But since you've already taken the time to listen to this webinar and you understand your options, you understand what's going on, we're willing to make a special offer. It's a 60-minute estate planning consultation, and we're going to waive any of those costs or fees that are set up to meet with us. And that is only if you take the next step before midnight. Otherwise, we'll charge the normal consultation fee of $500. And so we're offering you a 60-minute session with me where we can come up with a plan. You know, if at the end of our meeting you decide that you don't want to move forward, it's not going to cost anything. We won't do anything. But more importantly, you know, obviously you can't put price on peace of mind. How much? What's the investment? You know, most estate planning attorneys charge between $4,000 and $10,000 for a plan, depending on what all you need. And when you think about the thousands or hundreds of thousands of dollars that your family could be out, it's worth every penny. Now, I also want to tell you something else. With most law firms, what you don't know is that they bill you by the hour. Every phone call, every question, every small request, it all adds up. Then weeks later, you're going to get a surprise bill in your mailbox. Way more than you expected, but that doesn't happen here. We do things differently. Nothing that we do is billed on an hourly basis. Every service that we provide is a flat fee. It's going to be agreed on in advance, so there's no hidden fees, no surprise invoices. You always know exactly what you're paying before we begin. And because of that, we actually encourage communication. We want you to ask questions. We want you to reach out. Feel confident that your plan is done right without worrying about getting that bill for every conversation. You know, and that's the way estate planning should be. It should be clear, upfront, and stress-free. But there is a catch. You know, this offer, it's only limited. We can only take on a small number of clients each month. I'm happy to tell you that we average about 7,000 people a month on our website. But once our calendar is full, you're going to have to wait. And what does waiting mean? It means putting your family's future at risk. So if you want to guarantee that your family's taken care of, now is the time to act. You know, it's 100% risk-free. I know that making legal decisions, they can feel overwhelming, but that's why we're offering this 100% risk-free guarantee. If after our initial consultation, you don't feel completely confident in your estate plan, we won't go forward. You won't owe me a dime. You have nothing to lose except the risk of leaving your family unprotected. Imagine the peace of mind you'll have knowing that your loved ones are secure. Imagine never having to worry about courts, probate, or financial disputes. Imagine protecting your wealth for future generations, leaving behind a legacy that truly matters. Now stop imagining, click the link and get started protecting your family now. You know, what are those next steps? When you claim your spot, we will schedule an initial call. It'll be about a 15-minute call just to make sure that it makes sense for us to meet and plan out your estate plan. You can either click the link or you can go to our website, jasonenglishlaw.com/EP, or call us at 512-601-5843. Now, you've got to schedule that call by midnight tonight, or any meeting will be at the regular price of $500. Just to be clear, we don't have to meet tonight. You just have to schedule that 15-minute call by midnight tonight. And after that first call, we'll look for a time that works for everybody so that we can meet, figure out your goals, and come up with a great plan. So click the link to set that up while we still have spots. I just want to say thanks. Thank you, truly, for attending. I truly appreciate your time and your commitment to protecting your family and your family's future. Talk to you soon.